controversial contractor Sarah Discaya surrenders to the NBI ahead of an arrest warrant against her. Meanwhile, the Department of Justice finds prima facie evidence to charge Bilyonaryo Atong and more than a dozen others with kidnapping with homicide in connection with the missing Sabungeros. Good morning, I'm Atty. Jimeno, and this is At the Forefront. A major breakthrough in the case of the missing Sabungeros, as the Justice Department orders the filing of kidnapping and homicide charges against Atong and several others. But Ang's camp brands the charges as flawed and unfair. Meanwhile, an arrest warrant has yet to be issued against contractor Sarah Discaya and DPWH officials over a 100 million peso ghost flood control project in Davao Occidental. Discaya is currently under the custody of the NBI. To help us analyze these cases, we'll be speaking with Attorney Tranquil Salvador. He's the Dean of the School of Law and Jurisprudence at the Manila Adventist College. He's also a member of the Supreme Court's Technical Working Group on amendments to the Rules of Criminal Procedure. Good morning, Dean Tranquil.
Good morning.
Well, the big news po last night was the DOJ's resolution saying that they have found prima facie evidence with reasonable certainty of conviction to indict Atong and others for kidnapping with homicide and serious illegal detention. And this is in relation to the missing Sabungeros case. So others were asking me last night, makukulong na ba si Atong i-arrest na ba siya, at saka yung iba pa? Can you break down for us the process? O kasi lahat akala after this news, biglang i-aresto na, di ba, si Atong and others.
Yes. Very good question. I think we have to walk them through the process. So the first part has been completed. That is the process of preliminary investigation, which is a mandate of Rule 112. And in the process of preliminary investigation, those respondents were required to submit their counter affidavits. That's the process. And probably there's a reply, a rejoinder. Now, as you said, there is already a determination of what? Prima facie evidence, okay, of reasonable certainty of conviction. What does that mean? They have already determined, they have already resolved. There is a resolution and there will be a corresponding criminal information to be filed in court. The mere issuance of a resolution by the Department of Justice does not result to the issuance of a warrant of arrest by the department, because the department cannot issue a warrant of arrest. The question is, who issues the warrant of arrest? It is the court and only the court that issues a warrant of arrest. Let us say that criminal information prepared by the Department of Justice has been forwarded to the court. Then within 10 days from the filing of the criminal information, the court to whom it was assigned or raffled will determine within 10 days, based on the personal assessment of the judge, whether or not to issue a warrant of arrest. And that's what you call a judicial determination of probable cause on the part of the judge.
Okay. So, meron pa talagang time, no?
Yes.
That informations need to be filed in court first.
Yes, tama.
And the determination of the judge sa pag-issue ng warrant of arrest, when can the defendants here or the accused ask for bail or apply for bail?
Again, that's a very good question. You know why it's a very good question? Because the nature of the offense is, if I'm not mistaken, kidnapping and serious illegal detention. By the very nature of the offense, the maximum penalty of the same is reclusion perpetua or life imprisonment. Now, what does it mean? Ordinarily, not ordinarily, cases of that nature, I would like to be very clear, there will be no bail recommended. If you get to see the criminal information, there will be no bail recommended. Then some of the people watching us would say, oh, he's not entitled to bail. That's the right of a person under the Constitution. Hang on. The same Constitution says that if the nature of the offense is just like that, where the penalty is death, life, or reclusion perpetua, the burden is on the prosecution to establish that the evidence of guilt is strong. Therefore, only then, if it does not appear in court that the evidence of guilt is strong, only then can the court grant bail? There will be a petition filed by the counsels of these people. There will be a petition for bail. It is not the usual type of bail as a matter of right.
Yeah.
Those types of offenses, when you file it, you could immediately file bail, apply for bail, and post the necessary bail. No, this is a bit different because of the nature of the offense.
So in this case, assuming the court has already issued a warrant, kung i-serve yung warrant kay Atong Ang and the others that were indicted, they would have to go to jail first before, pending the application for bail.
Exactly.
Yeah.
Exactly. What happens is that they will be placed in prison, their lawyers will file a petition for bail, and then, again, based on the existing guidelines on continuous trial issued by the Supreme Court in 2017, he will first be arraigned. That's a requirement. And though he files a petition for bail, only after arraignment will it be heard. So there's time. And probably if they get to be arrested, they will be imprisoned for the time being.
Well, Atong Ang's lawyer, Gabriel Villarreal, described the DOJ resolution as deeply flawed and grossly unfair. And he said they would likely file a motion for reconsideration of the DOJ's resolution. So would that affect the timeline for the issuance of a warrant of arrest?
Actually, that is a very common question for counsels for the accused. If you read the provisions of the Rules on Criminal Procedure, you will not find exactly a motion for reconsideration at that level. However, it is the usual practice of lawyers like myself to file a motion for reconsideration. But this is the catch. Yes, you could file a motion for reconsideration, but that does not necessarily mean that the DOJ will not forward the criminal information. Because it's possible that they file a motion for reconsideration on the resolution, but again, the criminal information gets to be filed. So the very moment the criminal information gets to be filed, then the judge determines existence of probable cause, that if the judge finds within 10 days, he issues a warrant.
Okay, so pwedeng kahit pending pa yung MR nila, magkaroon na ng warrants of arrest.
Yes.
Well, in this case, there's really the testimony of Patidongan as that was relied on to point to Atong Ang and the others. But with the DOJ's internal rule that now requires probable cause with reasonable certainty of conviction, does the burden of proof change in terms of how much they can rely on just the affidavit of Patidongan, of one person?
Let us explain this to them. Reasonable certainty of conviction. If you read the Rules on Criminal Procedure, what does it say? It says probable cause. And with this circular of the Supreme Court saying that it's reasonable certainty of conviction, it actually increased the quantum. In fact, this is favorable initially for those who were sued, because the burden is on the prosecution to establish that, the minimum elements of the crime have been established. Not the evidence, of course, that will be in the course of the trial, but the minimum elements of the crime have been established. Only then, based on the quantum of proof today, will there be reasonable certainty of conviction, and it will be filed. Unlike before. Before that circular, all that is required before was whether there is sufficient ground to engender a well-founded belief that the crime has been committed, and responded was probably guilty thereof. Sa Tagalog, it's paring ginawa niya. Probably, potentially, parang ginawa niya. Ganon. Ngayon, tumaas eh.
Yung hurdle mas mataas na.
Yes, ngayon, if there is a finding of probable cause with reasonable certainty of conviction, it only means the message is all of the elements are present for the time. But it doesn't mean you're convicted already.
Yeah,
Don't
of course, that would be for the court's determination. Yes. And how important was the discovery of bones, of human bones in Taal Lake?
Well, I would assume, I'm not privy to the records of the case, but I would assume that there is a reasonable connection. Because, of course, there will be forensic experts, there will be medical experts who may have examined the bones. And all they need is to establish a connection.
Well, the other thing that, of course, people are wondering about would be the link with Gretchen Barreto, because she's one of the known personalities that was also mentioned as being involved in this case. But the DOJ dismissed the complaints against actress Gretchen Barreto, And a panel of prosecutors said the evidence against her and the so-called Pitmaster Alpha group is speculative and uncorroborated. So how do prosecutors determine whether a person's alleged involvement is too weak to merit charges?
Well, the barest minimum that a prosecutor or a group of prosecutors would rely on will be affidavits. Affidavits of witnesses who have personal knowledge of what actually transpired, probably including documentary evidence, but I do not foresee documentary evidence here. What I see here are testimonies of witnesses, personal knowledge, whether or not they could point to her actual participation. So a mere say-so, speculation, probabilities, conclusions by a playful mind will not in any way lead to a filing of a criminal action or a criminal information in court.
Well, Atong Ang previously filed complaints of attempted robbery and grave threats, among others, against Patidongan back in July. How will this affect yung case naman against Ang for the missing Sabungeros?
Well, that case filed against Patidongan by Mr. Ang would continue to proceed, just like any criminal complaint. But as to how it will play up, that remains to be seen during trial. Because there's already a case against them. There's a finding of probable cause based on reasonable certainty of conviction. And therefore, they may want to raise it during the trial that this is why Patidongan did it, this is his interest. There are things that may have led him to make such conclusions or imputations. That's for his lawyer to tell the court.
But in the meantime, both cases will proceed.
Yes,
right?
separately.
And then last month, the Rizal Provincial Prosecutor's Office affirmed its earlier finding that Julie Dondon Patidongan should be prosecuted for frustrated murder. And this is in connection with a shooting incident 6 years ago. How will this affect his role as a witness in the missing Sabungeros case? But before you answer this question, we'll have to take a short break. At the forefront, we'll be right back. Welcome back at the forefront, and we continue our conversation with Dean Tranquil Salvador. Dean Tranquil, with respect to Julie Dondon Patidongan, last month, the Rizal Provincial Prosecutor's Office affirmed the earlier finding to find him for prosecution for frustrated murder. But this was 6 years ago, a shooting incident 6 years ago. But how does this affect his role as a witness in the missing Sabungeros case?
Okay, let's discuss it in 2 points. The first is that case will have to continue. For as long as there is what you call, it is not yet prescribed, it will have to go its own way. On the matter of whether or not he could be a witness, whether that would affect him as a witness, let me tell you what the rules tell us when it comes to evidence. On matters of conviction, you could be asked, your previous conviction, and that may somehow affect the credibility of the witness. However, for cases which are actually pending, there is some sort of a limitation on whether you could ask those. However, there are very good lawyers who could bring that to the attention of the court. And we don't know whether it will prejudice or affect or in any way have an impact on the proceedings in connection with the Atong case.
Yeah, but generally, prior convictions, do they affect the credibility of a witness?
It's for the judge to determine. Remember, at the end of the day, it will be the judge who will hear it. It will be the judge who will assess it. But as to whether or not the fact of the previous conviction could be raised during trial, yes, it could be asked of a witness. It's clear in the rules.
Okay. Well, as for the flood control controversy, nagsalita na si Ombudsman Boying Remulla and even President Bongbong Marcos himself. They've said that merong mga magpapasko sa kulungan. But, you know, some people are complaining na medyo mabagal daw yung takbo ng pag-file ng charges at saka wala pa silang nakikitang naaresto na mga big fish or politicians. But as of yesterday, si Sarah Discaya, who's one of the biggest contractors, surrendered herself to the NBI. But this is ahead of a warrant of arrest being issued. What is the implication of that?
Well, let us tell the public that first, the ombudsman doesn't issue a warrant of arrest. In the same manner as I've explained to you, if charges are properly filed in the Sandigan Bayan, criminal information, it's the Sandigan Bayan that issues the warrant of arrest. Now, let's look at the voluntary act of Discaya. Why did she volunteer or surrender before the NBI? I think, to my mind, it could be in two ways. First, to show I'm sincere. I'm sincere to cooperate. Probably you may want to consider the thoughts of I being a state witness. I think that's a message that they would want to bring. Another possibility would be, well, this is to show communication, okay? A communication to the public that, you know, if I really want to suppress evidence, I won't. So even before they issue a warrant of arrest, I'm already here.
So the cooperation
Yes.
to like the rule of law and submitting herself
To the processes
to the process of prosecution. But magkaiba yung process ba when it comes to, because for that ghost project in Davao Occidental, in relation to which Sarah Discaya surrendered or appeared before the NBI, meron namang mga sinabi rin si Ombudsman Remulla that they would be arresting people starting next week. Is the process different when it comes to the Ombudsman and the DOJ?
There's really not much of a difference. Remember, what they're doing now is to conduct preliminary investigation. The same. The question is, does the Ombudsman have the power to conduct preliminary investigation? Yes, they do. Now, and why does the Ombudsman make such a statement? We will arrest you probably based on their, this is just probably, based on their initial assessment, they feel that the evidence against these people are strong. So once they come up with the resolution, then the process starts.
Oh, they mean
in court.
Yeah, which would be Sandigan Bayan.
Yes,
when it comes to politicians or government officials.
Yes.
Yeah.
For as long as they're salary grade 27 and the acts committed are violation of the anti-graft law 3019, plunder, offenses under the revised penal code like bribery, indirect bribery, or corruption of public officers. All of those types of offenses, including civil or criminal forfeiture.
Okay. This is really very helpful for the audience as to have a dean and a criminal procedure expert explain this. Kasi nalilito na yung mga tao, saan ba nakafile? And ano naman yung ombudsman compared to the DOJ, right? And iba rin yung korte pagka public officials, then they tend to be heard sa Sandigan Bayan.
I think this is just a thought. No? I think that on the part of the ombudsman, they know what the case is about, but what they're trying to do is to also manage the expectation of the public. As you said, may iba nagsasabi, it's not as fast as they expected. So there are people watching. They know that. And by making communication statements that would somehow assuage the public, we're doing everything. Just wait.
So how important is it for the ombudsman to already have people arrested by next week?
Well, you know,
for their credibility.
You mentioned credibility. And let me, for a more diplomatic word, let me say communications. Okay. Well, it's very important because they made statement as early as November. That before Christmas, around December 15, we will be issuing this resolution and we will be arresting. So, you know, the memory of the people is really good. They will remember, sinabi mo. Sinabi mo. Now, come January and there is January and there are no arrests. They will say, ano nangyari?
Magrarally sa mga tao.
Ano nangyari? Bakit walang ganyan? Yan lang na mahirap pag, pag you say that ahead. Because there is a process and they know that. But again, the challenge for them also is that the public as a whole is waiting.
Yeah.
It's also a perception game.
But how can warrants of arrest be issued against either politicians or government officials, including those involved sa DPWH, if wala pa tayong naririnig na nag-preliminary investigation na yung ombudsman? Is it possible that they would skip that process? They will rely on affidavits from the Blue Ribbon Committee hearing, and then just file the complaints, the charges directly with the Sandigan Bayan for the Sandigan Bayan to issue the warrants of arrest.
You know, the preliminary investigation as a process in the ombudsman is more or less the same as in the Department of Justice or in the Office of the Prosecutor. The other party is given 10 days to file its counter affidavit. In fact, after the counter affidavit, they could already make a resolution. In fact, but sometimes they would say, this is a very complex case. We will require the party, the plaintiff, to comply, or the complainant to file a reply, and then the respondents rejoinder. But the truth is, if they really are able to manage it, they could easily determine probable cause. They could come up with a resolution. I think, to my mind, they're conducting preliminary investigation.
Right.
You remember a few weeks ago, there was already a criminal information filed against Saldico and his company, right? He's not here. Remember, some of them would say, why did it happen? How can that happen? There is an express provision under Rule 112, Section 3D, that if a person cannot be subpoenaed, or if subpoenaed does not file a counter affidavit within 10 days, then they could resolve. That's what happened to him. So therefore, I would suppose that these people have been required, the respondents have been required to file their counter affidavit. If they don't, that's
even
their
yung
problem.
mga senators na naririnig nating mga pangalan, like for example, former Senator Bong Revilla, it is possible that he's already been asked to file a counter affidavit.
It's possible. Probably we're not aware. We're not aware. And proper notices or subpoena have been issued. We're just not aware. But what I'm trying to tell you is this. Preliminary investigation is a statutory right. So therefore, jurisprudence tells you it could be waivable. But it does not necessarily mean, the ombudsman will ignore it. No. When we say that, the other party may say, I don't want to file anything. That's his problem. Because there will still be trial. He will be informed of the charges against him. The information will be read to him. And then if he says plead not guilty, the same will proceed to trial.
And how sufficient are affidavits as evidence when it comes to plunder, graft, and corruption? Kasi nga, ang wala naman talaga dito is a physical na resibo, di ba?
Yes,
Hindi mo naman,
yes.
or maraming gumagamit ng mga middlemen. So, pagka merong na-implicate na politician, yung mga senators or congressmen, and gumamit sila ng middlemen, how likely is it to be able to prosecute the politician involved?
It's the personal assessment of the judge of the evidence, its admissibility. And this is where you need a very discerning judge. Because you'll be seeing people testifying saying, binigay ko ho dyan inabot ko ho dyan para ho sa kanya yun. And then the other side will say, I don't know you. You never brought anything to me.
Yeah,
yes,
which is the likely defense.
Your word against mine. It's an his and her statement. So that's where you have a need of a wise and discerning judge or justices of the Sandigan Bayan who will determine, sino ba talaga nagsasabi ng totoo dito? But if there are, for instance, electronic evidence like text message, magkita na tayo, iabot ko na sa'yo, you will have to authenticate that. Or for instance, there will be documents that would show a hand note, okay, come to this place, or he's entitled to this number of
text
millions.
messages.
Yes.
Is that admissible?
That's admissible. That's what you call ephemeral evidence. And that is allowed in our jurisdiction.
Okay. And finally, since wala na tayong time, based on where we are sa pace ng investigations, do you think it's possible that by next week, December 15 onwards, meron na talaga mga maaresto na politicians? Yun yung inaantay ng mga tao.
You know, I'm not God, you know. But what I'm trying to tell you is based on their pronouncement. I would just have to rely on their pronouncement rather than say that it will happen. But I'm hopeful. Again, the rest of us are hopeful that somehow something will happen in the next few days, okay?
Okay, thank you so much, Dean
Thank
Tranquil
you.
Salvador.
Yeah.
Always a pleasure to have you.
Thank you.
It's been 4 years since more than 2 dozen Sabungeros or cockfighting enthusiasts went missing in various parts of Luzon. Gambling tycoon Charlie Atong Ang's name has been linked to the case before, but it was only on Tuesday that charges were filed against him. Whether or not it's an ironclad case remains to be seen. Meanwhile, an arrest warrant has yet to be issued against DPWH contractor Sarah Discaya for a ghost flood control project in Davao Occidental. But there was no mention of a lawmaker implicated in the case. As the public continues to demand justice for these cases, we have yet to see if politicians will also be held accountable. Be timely informed, be insightful of the news. I'm Atty. Karen Jimeno. Always stay at the forefront.